Good morning. My name is Bethany Sweeny. I am an attorney at Kotz, Sangster, Wysocki PC in Detroit, Michigan. I am happy to be here with you today to discuss issues related to COVID-19 and legal issues facing human resources professionals. I am an employment attorney. I focus solely on employment issues related to employers, harassment, discrimination, handbooks, employer policies, terminations. So I'm pleased to be here to speak with you. I wish I could say that we are through with this pandemic, but obviously we all know that we certainly are not, that there are still issues that are facing all of us, and you especially as a human resources professional. So with that in mind, I'm going to get started on this presentation. So here we are. Human resources, COVID-19 a year later, legal issues facing human resources professionals. As we all know, this pandemic started in March of 2020 and our lives were turned upside down as employers. So where are we at? 1 year later, these are still challenging times. The COVID numbers in Michigan were surging in February and March of 2021. Michigan, as you are probably well aware, has the highest COVID numbers in the country right now, although it does seem that our numbers maybe are coming down slightly. Governor Whitmer had promulgated a number of executive orders, which after an outcry, she is no longer able to do that. So now MIOSHA and the Michigan Department of Health and Human Services are now the ones that are promulgating rules and orders, which we are all required to operate under. There are currently 2 COVID-19 vaccines available for use. We'll talk a little bit. There was a third, but that's been on pause. Michigan is slowly opening up, but we're still going to all have to adapt to a new normal. So our agenda for the day, we're going to talk about the COVID-19 vaccine generally, and then how it relates to employers. The American Rescue Plan Act of 2021. As you know, this was the act passed by President Biden and signed into law in March of 2021, which amends the FFCRA, the Families First Coronavirus Response Act. We're going to talk about MIOSHA, Michigan Department of Health and Human Services compliance. We're going to talk about return to work issues for those of you that are returning your employees to work or already have. We'll talk briefly about remote work issues, and then we're going to just touch on handbooks at the end of the presentation. So let's start with the COVID-19 surge. So as we're all aware, the surge began about 6 weeks ago. During that time period, COVID-19 the positive test rate was around 18%, which was about 5 times the rate in February. But as recently as Friday, the 16th, April 16th, the positivity rate was 12.1%. So there is some suggestion that the numbers are showing a downward trend. On November 20th of 2020, Michigan had reported a total of 9,779 COVID cases, which was its highest case total to date. But on April 16th, we reported 8,955 new cases, which is the second highest single day case total since the start. And Michigan right now is averaging approximately 6,732 new confirmed cases per day. So obviously our numbers are still high. There doesn't seem to be a total explanation or an explanation as to why Michigan's numbers are so high. So COVID testing as of April 21st, I'm sorry, that must have been, Michigan reported 121,298 total tests, which is the 11th most total tests in the US. I believe that should have been April 20th, I apologize. But when compared to tests per 1 million, Michigan actually falls to 25th with 12,182 tests at that rate. So there is some indication that testing is going down in Michigan, although our rates are going up. And Michigan has also recently expanded COVID-19 testing to individuals that have mild symptoms. So pretty much any reason now you can get tested for COVID in Michigan. And also recall under the newest orders, our teenage athletes are always also being tested on a weekly basis at the very least if not more. So we have hundreds of teenagers being tested in the state as well. So where can you get tested? The Michigan Department of Health and Human Services has a website, which is in this presentation, which will show you locations where you can get tested. And you can click on that link and it'll take you to, you can put in your location, so it can be location specific. Individuals can get tested at places like their physician's offices, CVS and Rite Aid always have drive-up clinics, urgent care centers, and some local community centers are also providing testing. So it really is dependent on where you are and who may be testing around you. So let's talk briefly about the COVID-19 vaccine. So currently, as you're aware, there's two vaccines available. There's the Moderna and the Pfizer-BioNTech vaccines. Both of these require 2 shots. The Moderna shots are given 28 days apart. The Pfizer shots are 21 days apart. An individual is considered fully vaccinated 2 weeks after they receive the second shot. As of right now, all Michigan residents 16 and older are eligible for this vaccine, but be aware that 16 and 17-year-olds are only approved for the Pfizer vaccine given their age. Obviously, you have to have an appointment prior to getting vaccinated, and the shots are free. As of April 16th, 2021, 2,393,122 residents of Michigan, or 29.6%, have been fully vaccinated. So recall at the beginning when the vaccines were coming out, there were issues with Michigan not being able to get enough vaccines. A number of people were driving to Ohio, Indiana, other states to get vaccinated. Ohio does not have a requirement that you need to be a resident of the state to be vaccinated. But it does appear that there are more vaccines coming in to the state of Michigan and availability is greater now. So we had a third vaccine, the Johnson & Johnson vaccine, which is a 1-shot vaccine, which following that shot, an individual was considered fully vaccinated 2 weeks after getting that shot. However, given that there was 6 cases of a rare and severe type of blood clot, the use of the vaccine was paused on April 13th, 2021. This was after 6.8 million doses were administered as of April 12th. The Advisory Committee on Immunization Practices met on April 14th, and they declined to end the pause, so we are currently still in a state of pause on the J&J vaccine. There is another meeting scheduled for this week to determine what the next steps are with the Johnson & Johnson vaccine. So things that could happen, they could decide to return to using the vaccine. They could decline to use the vaccine, decide that it's too risky, or they could determine that they could lift the pause and we could start seeing J&J vaccines being administered again. So if you have received the vaccine, the Johnson & Johnson vaccine, what they say is if you received it more than 3 weeks ago, the risk of developing a blood clot is likely very low at this time. If you did receive it within the last 3 weeks, your risk is also very low, and that risk decreases over time, but watch for the symptoms and report to your doctor immediately if you feel like you're experiencing any symptoms. So how to find the vaccine? Here's some listings. So things like there's the CDC COVID vaccine finder. You can go to your local health department or hospital, local pharmacies. I know Meijer, Rite Aid, Walgreens, some Walmarts, and some Snyder Drugs for the UP residents are offering them. And there's also a hotline you can call. But the COVID-19 vaccine and how it relates to you as employers, the biggest question that we hear is, can I require my employees to be vaccinated? And the short answer is yes. The EEOC did issue guidance earlier this year, which indicated that yes, an employer can mandate the vaccine with some exceptions. So if an employee requires an accommodation for religious reasons or because that employee may have a disability, you as the employer need to have a policy in place that allows for such accommodations and has a process for dealing with those types of accommodations. If the employee has a disability or a sincerely held religious belief, you will need to engage in the interactive process with that employee. And so we all understand what the interactive process is under the ADA. Right, when we do it for an employee that has a disability, we have a conversation with them as employers. How can we help you so that you can perform the essential functions of the job? It'll be similar here with talking to the employee if they decline the vaccine for religious reasons or a disability. And also consider whether or not you're going to mandate the vaccine for pregnant or breastfeeding employees. I can tell you anecdotally, most employers that I know are not mandating the vaccine. There are very few. I work with a number of healthcare providers, and they have not mandated it yet, although they strongly encourage it. So there are things to be thinking about, whether or not you're going to mandate it as the employer. Be aware that under the ADA, a vaccine itself is not considered a medical exam. And you as the employer, should you decide not to not mandate the use of the vaccine, you can request proof of vaccination if you want to, but remember that's confidential information and you shouldn't keep it in a personnel file, but rather it should be kept in a medical file. So consider if you're the employer that decides not to mandate the vaccine, or if you're thinking about mandating it, here are some considerations relative to mandating the vaccine. So what are you going to do if your employee refuses to be vaccinated? So you come up with a policy that all employees need to be vaccinated in order to return to work full time. Are you going to discipline the employee? Are you going to terminate the employee? Be aware that a terminated employee may possibly be eligible for unemployment if you fire them. Although, as we're all aware, the COVID is no longer a reason for unemployment in Michigan. So hopefully that will be easing up on some of the restrictions and getting people back to work. I know that a number of employers were having issues getting their employees to return to work because of the amount of money they could collect in unemployment. Also, you need to think about, as you're considering whether or not to mandate the vaccine, how's it going to affect your employee morale? One of the things I suggest is, are your employees receptive to the mask mandate? And if your employees don't want to wear a mask, are they going to want to get vaccinated? There is a lot of vaccination hesitancy in this country currently, as well as masks. And so a lot of times an employer can gauge whether or not they should mandate the vaccine based on how their employees are doing with having to wear a mask to work every day. Also, another thing to keep in mind is if your employees have not returned to work yet, and we'll talk about this, but now that the remote work requirement has been extended until October 14th of 2021, you do have some time to be thinking about whether or not you're going to be mandating the vaccine and to get some sort of policy in place if you do decide to mandate that. And quite possibly by the time we get to the point where offices are opening back up per the state of Michigan, maybe many of our employees will already be vaccinated and this will no longer be an issue for employers to grapple with. So some other things to be thinking about. What if the employee has an adverse reaction to the vaccine? Could that be a workers' compensation claim? If it's determined to be a work-related injury, could the employer be liable for requiring the employee to receive the vaccine? These are issues if you mandate it as the employer, not if you just encourage it. So if you were to encourage an employee to go and get the vaccine and they have some sort of adverse reaction, it's not a work-related injury because it wasn't work mandated. It wasn't work-related. You were just encouraging them to get the vaccine. You also have to think about Fair Labor Standards Act issues and wage and hour issues. If you mandate the vaccine, how are you going to compensate your employees? Are you going to have them get vaccinated during the workday? Are you going to have them get vaccinated after the workday? Are you going to have somebody come to your place of employment and provide the vaccine? Are you going to send them off to a clinic to get vaccinated? So these are other issues you need to consider, wage and hour type issues. For you that may have a unionized workforce, for you employers, we are hearing that, employers can face challenges from unions relative to mandating the vaccine. And potentially even a non-union employee could state a claim for a violation of Section 7 of the National Labor Relations Act. As I'm sure everyone is aware, usually we think of the National Labor Relations Board, the NLRB, for unionized employees, but they get very involved with non-unionized workforces as well. And under Section 7, the employer cannot interfere with an employee's protected concerted activity. And potentially mandating a vaccine could be considered a violation of Section 7. So obviously there's a myriad of issues that employers have to consider before they decide that they want to mandate the vaccine. But some of the things that we're hearing employers are doing, some major employers, let's say Target, Trader Joe's, some of the big ones, they have offered incentives to their employees to get vaccinated. So they're offering extra PTO or vacation days. They're providing some sort of monetary incentive, such as a bonus or gift cards. Another thing to think of is the leadership of your organization getting vaccinated. If they are, then that's something to share with the employees, that the leadership feels like it's safe to be vaccinated and it's important, and to share that employees. And really what you want to think about is the message that you have relative to the vaccine and how you're going to share it with your employees, because as we all know, education regarding the vaccine is key. There really is a lot of concern regarding the vaccine. And anytime an employer steps in and mandates anything, right, there is generally some sort of pushback. But when we're talking about something that you're injecting into an employee's body, you can understand why there might be some hesitancy. So the vaccine has been found to be safe generally. And so really how you share that message with your employees really is so important if it's something that you decide that you want to mandate, or even if you're just going to highly recommend that your employees get vaccinated. Being able to speak to them and with them about why you feel that way as an organization is important so that they understand. Okay, switching gears, we're going to talk about the American Rescue Plan Act of 2021. This was the COVID relief package that President Biden signed into law in March of 2021. And for purposes of this presentation, I will call it ARP or ARP. So signed into law on March 11th, 2021. It includes a number of provisions to address the COVID-19 pandemic, including many provisions that affect employers. So for example, the ARP extends the current 300 weekly jobless aid through September 6th for employees that are collecting unemployment. And it also made changes to the emergency paid sick leave, EPSL, and the emergency FMLA, EFMLA, that we were all introduced to under the FFCRA, the Families First Coronavirus Response Act, about a year ago right now. So let's briefly revisit the FFCRA and where we were. So the FFCRA required employers with less than 500 employees to provide their employees with paid sick leave or expanded FMLA for reasons related to COVID-19. It was mandated, and you were required as an employer to provide it through December 31st of 2020. And recall, your employees could not be able to work or telework in order to collect under the FFCRA. I spoke with a number of clients who were small businesses who sought the exemption because they thought that it would jeopardize the viability of the business as a going concern. So the reasons where an employer could have provided FFCRA under the EFMLA, the only reason was the employee could not work or telework due to childcare needs, meaning the school or daycare was closed due to COVID. Under the EPSL, there was 6 reasons, although honestly, any other substantially similar condition really was never explained. So there were really 5 reasons. So the individual was subject to a quarantine or isolation order. They had been advised by a medical provider to self-quarantine. They were experiencing COVID-19 symptoms and seeking a medical diagnosis. They had to care for a quarantined individual, or they had childcare needs. So again, under the EPSL, they were entitled to 2 weeks or 80 hours of paid sick leave. And depending on the reason, they were either getting paid $511 a day, up to $511 a day, or they were getting up to $200 a day, either $51.10 in the aggregate or $2,000 in the aggregate. And under the EFMLA, remember, full-time employees were entitled to 12 weeks of leave, which, again, recall the EFMLA was not separate from the FMLA. So if an employee already had used some of their FMLA, they weren't necessarily entitled to a new bank of 12 weeks of leave under the EFMLA. They were just entitled to additional, or to use the time that they had for COVID-related reasons. Recall the first 2 weeks at that time were unpaid, although for the first 2 weeks they could use their emergency paid sick leave so that they would end up with 12 weeks of paid leave. Then the remaining 10 weeks were paid at 2/3 of the employee's regular rate of pay, but was capped at $200 a day or $10,000 in the aggregate. The employee had to have been employed at least 30 calendar days, and the EFMLA could be used intermittently. Okay, so with the ARP, the FFCRA has been slightly modified. This started at the end of 2020. We were seeing when there was significant concern, I remember, from employers at the end of 2020, what was going to happen. Was the FFCRA going to be expanded? Was it going to be continued? You know, what was going to happen? And so what we have been finding out since the end of 2020 is we're at where we were relative to the FFCRA and its mandate, where we were at the end of 2020. So it's now voluntary, it's not mandated, so you can offer emergency paid sick leave or emergency FMLA to your employees. It is voluntary. I have a mix of clients. Some have chosen to continue it and some have chosen not to. I can tell you that for the employers that have chosen not to continue it, I get calls a lot. How do we handle this issue? How do we handle this leave issue? I have an employee that's sick. I have an employee with a childcare issue. What do we do? So it's fully up to the employer how they want to handle these. Some have chosen now that the tax credit has been extended until September 30th, 2021. If they provide the 80 hours of EPSL, a number of employers have decided to, at the very least, offer the emergency paid sick leave given the tax credit. And with the ARP, employees received a new bank of 80 hours. Even if they had used their previous 80, they now have a new bank of 80 hours. But be aware that that was not the same with the EFMLA. The EFMLA employees did not get a new bank of 12 weeks, right? Because that was tied to their FMLA, and there's so many different ways that employers provide FMLA and calculate it on a rolling basis, on a calendar basis. So employees were not given a new 12 weeks of EFMLA, but they were given a new bank of 80 hours or 2 weeks of emergency paid sick leave. So in addition to the reasons that we had previously discussed as to why an employee could take emergency paid sick or EFMLA, the ARP provided 3 additional reasons why an employee could use EPSL. And those would be to obtain a COVID-19 vaccine, to recover from the side effects of a COVID-19 vaccine, or if they're seeking or awaiting the results of a COVID-19 test or diagnosis, either because the employee was exposed or because the employer required the test or diagnosis. So now we have 9 reasons why an employee could be eligible for EPSL. I actually got a call a couple weeks ago from a client where, in fact, their employee was having side effects from the vaccine and they sent them home and they provided them with the paid time off under emergency paid sick. There are no changes. The tax credit is still capped at $511 a day or at $200 a day. The $511 now is, remember or recall or be aware that the reasons for collecting at $511 a day is if it's for one of these new reasons related to testing or vaccination, or because of the employee's own symptoms, quarantine, or isolation due to COVID. There were some changes as well to the EFMLA. Be aware now that the ARP has removed the requirement that the first 10 days of EFMLA are unpaid. So now the first 10 days of EFMLA are also paid, and employers can provide on a voluntary basis up to 12 weeks of qualifying paid family leave per employee. So technically an employee could be eligible for 14 weeks of paid time off. So they would have 10 or 2 weeks under EPSL, and then they would have another 10 or 12 weeks, 12 weeks under EFMLA for a total of 14 weeks paid potentially. But the cap on the aggregate and the cap on the aggregate amount has correspondingly increased from 10,000 to 12,000, given that there's the extra 2 weeks that they could be paid. And now under EFMLA, an employee can take off EFMLA for all the reasons for which they could have taken under paid sick leave. And for EFMLA, there's no change. The tax credit is still limited to a maximum of $200 per day for all reasons, including the new reasons under the EPSL. Another new addition to the ARP is employers are disqualified from receiving the tax credit if they fail to comply with any of the provisions of the FFCRA, including its anti-retaliation provision, or if they discriminate in favor of highly compensated employees or full-time employees. So you can't refuse to allow somebody time off under the FFCRA if they're one of your lower paid workers, and you can't refuse to provide the time off if they're one of your highly compensated employees. So all employees now under EPSL and EFMLA must be treated the same. And it's always helpful. There's the Q&A from the Department of Labor regarding the FFCRA, which is updated occasionally. And so I provided the website for you, which provides a really good explanation from the DOL. Okay, some other issues that employers should be aware of under the ARP. So there were changes to COBRA. So from April 1st, 2021 through September 30, 2021, group health plans providing COBRA continuation coverage must offer 100% subsidy of COBRA premiums for assistance eligible individuals and their qualified beneficiaries. The subsidy requirement applies to major medical, dental, and vision plans. An individual is an assistance eligible individual if she or he qualifies for COBRA coverage due to involuntary termination of employment or reduction in hours. But individuals who qualify for COBRA coverage due to other qualifying events are not considered to be an AEI eligible for the premium subsidy. So we're really looking at individuals who are involuntarily terminated. And importantly, the ARP includes specific requirements for employers to update their COBRA notices or send separate notices describing the new subsidies to all eligible individuals within 60 days of April 1st, 2021. So importantly for employers, right, it's April 20th now, so the clock is ticking on this 60-day notice. So that is definitely something to be aware of and to be acting on to the extent you're offering COBRA. For spending accounts, remember that the ARP raised the 2021 contribution limits for dependent care flexible spending accounts to $10,500 for single taxpayers and $5,250 for married individuals filing separately or single filers. And the change goes into effect for the plan year beginning after December 31, 2020, but before January 1, 2022. So basically calendar year 2021. Okay, so we talked about the FFCRA and issues related to leave or time away from work for COVID due to um, under the FFCRA or emergency paid sick leave or emergency FMLA. But remember, as employers, you're still obligated to follow the mandates of the ADA and the FMLA. So just because the FFCRA is not mandated, the ADA and the FMLA are still out there lurking in the background. So there's always issues that come up, right, during these pandemics. And we all struggle with the ADA and we struggle with the FMLA and how do we apply it and how does it work? So, right, a question we get, does a positive COVID test equal FMLA leave? Again, look at what the look at what the FMLA requires. Is there a period of incapacity of more than 3 consecutive days and continuing treatment? Is it inpatient treatment? So you would need to consider if an employee, right? So we do have some employees who maybe they're the long haul COVID individuals who are sick for an extended period of time. Not everybody gets it and experiences no symptoms or mild symptoms. Some really are sick and some are off because they're hospitalized. Consider that potentially as an FMLA situation. So don't forget your obligations under the FMLA for COVID. And how about individuals that have or employees with underlying health conditions? Would the ADA be implicated? Do they trigger an FMLA leave? So remember, there has to be a connection between the medical condition and the inability to work. Remember that there are required FMLA notices to be sent out. It would be treated like any other FMLA situation. And for ADA issues, remember that you need to engage in the interactive process, which we had discussed briefly earlier when thinking about whether or not you were going to mandate the vaccine. And you need to consider reasonable accommodations as necessary, which could potentially be a leave of absence, unpaid or paid. Another issue that we see come up, and we saw this a lot, especially at the beginning of the pandemic, employees that didn't want to come back to work because they lived with somebody that was potentially high risk. Got lots of calls from employers about that and how do we handle situations where our employees refuse to come into work because they're concerned that they were going to contract the virus or they were concerned that they would be exposed and then give it to somebody that they lived with. So when it comes to caring for a family member that has COVID, would that bring the FMLA or the ADA into play? So be aware the ADA does not require employers to accommodate an employee's family member with a disability. The ADA requires that you accommodate the employee, not a family member. Also, an employee without a disability of their own is not entitled under the ADA to work remotely as an accommodation in order to protect a family member with a disability from potential COVID-19 exposure. So an employee can't claim that they want to work remotely as a reasonable accommodation under the ADA because of a family member. Again, it's only applicable to the employee himself or herself. Under the FMLA, depending on whether or not the employee's relative would be considered, would that employee's family member have a serious health condition? Remember, under the FMLA, that employee can seek leave to care for a qualifying family member with a serious health condition. But again, we need to look to the FMLA and the regulations and see who would be considered, a qualifying family member. So is it a parent, a spouse, a child? Remember when we started getting into aunts and grandparents and step in-laws that potentially, these are not qualified family members. So if the employee's family member has a serious health condition, i.e. COVID, and they may be hospitalized or struggling with the illness, the employee may be entitled to an FMLA leave to care for that qualified family member. But probably an employee can't take FMLA leave to care for a family member with a compromised immune system who is simply trying to avoid getting COVID. So again, as always with the FMLA and the ADA, it's this dance that we do with our employees to make sure that the reasons that they're seeking to be off of work are legitimate reasons under the FMLA or the ADA, I don't mean to be cynical, but we all know that there is some gamesmanship that goes into FMLA or ADA requests. And let's not forget then that during this pandemic, the way that we acted prior to the pandemic with regard to the FMLA and the ADA are still relevant and important during this pandemic. Okay, let's switch gears a little bit, and now we're going to talk about MIOSHA and the Michigan Department of Health and Human Services compliance. So I would say in the past week, there's been a little bit of activity from both MIOSHA and MDHHS. The one order was set to expire on April 14th. And so MIOSHA issued new emergency rules that went into effect on April 13th. And one of the biggest was the 6-month extension of the current emergency rules, extending them until October 14th, 2021. There was no change, really. They're identical to prior emergency rules. The biggest issue is that they were just extended another 6 months. And importantly, under MIOSHA, the employers are continuing to have a policy in place to prohibit in-person work to the extent that work activities can feasibly be completed remotely. Now, interesting enough, in the past month or so, we've been hearing from MIOSHA that there is not a rule in place that prohibits in-person work, although many of us who are employers or work with employers, interpret MIOSHA's rulings differently. But there are plenty of employers that have employees back to work during the pandemic that are not considered essential employers. So obviously essential employees can be working. But I do have clients who have employees that are in the office working because really their activities cannot be done remotely. Some employees are in the office because they want to be, and some are in the office because the employer wants them in. But that really is what you need to be considering as the employer, to the extent you have employees and you're still grappling with, are we bringing them back? Are we not bringing them back? Which ones are we bringing back? So if the work can be done remotely, it should be done remotely under this MIOSHA emergency rule. If it can't be done remotely, then consider bringing them back. And obviously with the vaccine, I just saw this with another client. There is no guidance yet from MIOSHA or MDHHS as to whether or not a fully vaccinated employee can come back to work. I have seen no guidance of that to date. We do have clients that have asked us, now that we have employees that are fully vaccinated, can they come back? So I can only say at that, stay tuned. Maybe MIOSHA will issue additional guidance relative to fully vaccinated employees. Michigan Department of Health and Human Services also issued an emergency order last week. Their order extended limitations on gatherings and mandating face masks until Monday, May 24th, 2021. The order went into effect on April 19th. And really, it pretty much extended the requirements of the current emergency order issued on March 3rd. Probably the most notable thing with the April 16th order was it expands face mask requirements to all individuals 2 years and older, and exempts fully vaccinated individuals at residential gatherings from the face mask requirements. So those really are the big changes. I think what we're seeing here is just a continuation of what had been in place previously. Depending on where we are with the surge, restrictions are easing, or they're going back to, a little more stringent. You may recall within the past month, they went back to requiring a 14-day quarantine period. It had dropped to a 10-day quarantine period, but the state moved back to the 14-day quarantine period for those that had been exposed. So what you were doing before, you should continue to do now. These new orders and rules that have gone into effect in the past week really are not making a huge difference for employers. And you can see on this slide that the latest order from the Michigan Department of Health and Human Services is at that website I provided. Okay, so I think probably by now employers are either comfortable with their employees returning to work or comfortable having their employees working remotely or having some sort of combination of the two, depending on the business. For those employers that maybe are planning for a return to work. So the state of Michigan, so I think really before the surge, the state of Michigan had put together this, quote unquote, return to office work group. It was a bunch of experts, quote unquote, in the state of Michigan that was finalizing recommendations on best practices for in-person work when permitted in office settings. Before the surge, there really had been some suggestion that, in fact, as these recommendations came out from this work group, that they would be implemented, really kind of giving hope to employers, I think, that maybe employees would be able to return to work sooner rather than later. And then, of course, we had this extension of the October 14th date for return to work. Although Governor Whitmer has indicated that any recommendations from this work group could result in amendments to the safety rules in advance of October 14th. So as with everything, kind of stay tuned, and pay attention to new proclamations from the state regarding when our employees can return to work. So things to think about if you're planning a return to work for your employees. You have to have that written COVID-19 preparedness and response plan. You have to provide training to your employees that cover workplace infection control practices, proper use of personal protection equipment, the steps workers have to take to notify business of COVID-19 symptoms or a suspected or confirmed diagnosis, and how to report unsafe working conditions. And the business must adopt protocols for safety, such as employee self-screening, social distancing, hand sanitizer, masks, etc. I think MIOSHA did a nice summary of the guidelines for offices, can be found at this website that's provided. And just to reiterate, I see all the time these notices from MIOSHA about businesses that are being dinged because they don't have their preparedness plan in place, because they're not doing training, because they're not requiring their employees to wear a mask. A myriad of reasons. Right? We see it in the news. The restaurant owners that are getting in trouble, the barbers. But on a weekly basis, MIOSHA publishes who has been penalized under these emergency rules for not following the guidelines. So to the extent you're bringing your employees back, really having the plans in place is key. I know employers that have been dinged for not having that preparedness plan. So please, if you ever need help with any of the issues, I know because this is a recording, we're not taking questions, but my contact information is in the slides, and I am certainly able to offer guidance on any of the issues that come up during this webinar. So please feel free to reach out on any of the issues or any other COVID issues that you may have questions about after you watch this presentation. So remote work, which a lot of people are still engaged in, a lot of employers, although in the boating industry, maybe you have some more employees coming into work. So it's interesting. One commentator suggested that the biggest impact of COVID-19 may be remote work, and how many more people are doing remote work, and how attitudes have changed regarding remote work. And so pre-pandemic, about 5% of full-time employees with office jobs worked primarily from home. And now they're guessing that post-pandemic, it's going to be closer to 20 to 30% in this new normal, quote unquote, that we're dealing with. So there really has been a pretty seismic shift in thinking and doing as it relates to work from home attitudes. We're seeing that location may be less important in hiring. I just see, postings for employment positions where a number of them are now remote. So I could be living in Michigan and advising in other states based on some of the postings that I see. So, right, our hiring practices may not just be limited to if I live in Traverse City and work in Traverse City, maybe I can hire somebody from Montana to do my job. So we're having, shifts in how we think about hiring and workers in general. There's the thought that more workers will live farther from city centers in different parts of the US or even outside of the country. There was just an article in the Free Press a couple weeks ago that one of the Michigan State Supreme Court justices was living and working in Israel and Dubai while doing the work for the Supreme Court, the Michigan Supreme Court. So there are examples all around us of individuals living one place and doing work somewhere else. I think many employers expect remote work to become the new normal to the extent it can be done from home. And one survey of approximately 800 employers showed that 94% of them said that productivity was unaffected or even improved compared to pre-pandemic levels. So I think one of the concerns that I'd always heard from employers was if my employees work from home, they're going to be less productive. They're not going to get their work done. They're going to be distracted. A whole host of reasons, legitimate reasons as to why we think that remote work wouldn't work. But I think we're finding with this pandemic that it can work, and it does work. But the concern may be culture, right? That could be one of our concerns. When your workers aren't in the same office, when they're not physically interacting with each other, when they're not standing at the water cooler talking, when they're not in the kitchen having lunch together, right? There is that disconnect potentially between our employees. There can be harder to establish a sense of culture amongst our employees. And that is a struggle for employers. How do we keep our employees engaged with each other while they're still doing their work remotely? And that's something that employers continue to grapple with. So just to the extent you continue to have your employees work from home, a year into this, some considerations, any policies that you have, you need to consistently and fairly apply them to avoid claims of discrimination or retaliation. There has to be that determination of which positions can be done remotely. Not everyone can work remotely, and a lot of people can. You need, as the employer, to find ways to continue to support and engage your employees, whether that's, Zoom meetings or Microsoft Teams or, weekly calls, whatever you can to keep your employees engaged. I know when the pandemic began, I did a number of teleworking policies, so that's an important thing to consider having in place. Be mindful of security or confidentiality issues when our employees are working someplace other than the office, to make sure that networks are secure, that if there are confidential issues that they're dealing with from home, that they are in a location where they can maintain confidentiality. And also something I had mentioned previously, understand that wage and hours issues may be implicated when employees work remotely. So we see this a lot when an employee lives in Michigan but is doing work for an employer in California or Washington State or Florida. And how does that impact wage and hour issues or FLSA? There's also issues we see a lot with employees who maybe worked in California or New York were making more money for cost of living reasons, commuting, whatever else may be. But when they stopped commuting, employers then started questioning, should they be being paid as much as they were before when they're not, and maybe they're not commuting from Connecticut to New York, or where they're living does not justify a higher wage. So obviously there's wage and hour issues that may be implicated with remote work from home. Okay, our last issue of the day is handbooks. Right, so I always recommend to my employers that updating handbooks on a regular basis is really important, right? We all know employment law. It is changing all the time. We saw this just in the past year, right? So we had an FFCRA that came out, um, and then that changed and was modified, or we had the Michigan Paid Medical Leave Act. So there's always things that are happening in the world of employment law. So it's always a good idea that if you haven't updated your handbook in the past year or two, that you really should consider having your handbook updated. And of course, to the extent you don't even have a handbook, having one in place is always important. So if you are one of the employers who doesn't have a handbook in place, please feel free to reach out. I do have a pretty short and to the point handbook that I could share a template. But one, having a handbook is important, and two, having it updated is just as important. And so COVID has required a lot of new policies that maybe we never considered should be part of the handbook before. And so the question is, should they be part of a handbook now? Right? Should we be, as employers, revising our handbook to include policies that are COVID specific? And my recommendation is probably not. I don't know that we want to start the process of revising handbooks and then distributing to all of our employees entire new handbooks. But what I do, right, is think about it, when we maybe update a policy, what do? You shoot it out to all your employees via email, or you tell everyone it's available on a company intranet kind of thing. And then you have them sign off that they've received that new policy. So there are policies that we're going to talk about briefly that you may want to consider as standalone policies that you would want to have in place during this pandemic. And of course, I can certainly help with any of these policies that we're going to discuss. So what should we be thinking about as employers? Do we want teleworking or a telecommuting policy? Any FFCRA related policies? Obviously, well, you're not required to. I know a lot of employers that are still providing FFCRA, so they still have their policies in place. Think about dress code policies to address masks or face coverings. There's been so many issues arising over employees and what do they have on their face masks, and is it allowed at work, and are they making a political statement with their face masks or face coverings? So that might be something to think about in your dress code policy. Or what's your travel policy now that employers or employees are not traveling as much? So you might want to think about your travel policy, a COVID-19 testing policy, or even a workplace safety policy that's specific to COVID-19, like social distancing, in-person meeting procedures, capacity limits, temperature checks, those kinds of things. So there are policies that you might want to think about that are COVID specific, that you might want to just have in place as standalone policies. So again, any of these policies I can help you with, should you decide that you would want to implement any of those. So that is the end of the presentation. I'm sorry that we weren't able to do this in person so that individuals could ask questions. My contact information is on this screen. Please feel free to reach out either via email or give me a call if you have questions relative to this presentation. I enjoyed the opportunity to present to you, and good luck with the upcoming voting season. Thank you.